Hi friends, welcome to the fourth class of Law of Torts, and the topic for today is vicarious liability. So vicarious liability is also called as no fault liability. So to whom this liability holds? Actually this liability is applicable to the owner or the person who is giving commands or instruction to the servant. So if we go to the background of this, we have to say that generally every person is liable only for his own wrongful acts. But under the law of torts, there are some circumstances or relations when the person will be liable for the wrongs not done by himself, but also for the wrongs done by others too. And this liability is known as vicarious liability or no fault liability. Now there are some modes by this liability is created. In general, if you see, the first mode is ratification. In Hindi it is called anusamarthan. Means if the master or owner, he is a servant and servant does something wrong, but the master says don't do it, but at the same time he pay him as a compensation for doing that act, it means he is ratifying his act, and then in that case the master will be liable. Another case is abatement. If somebody abates or encourages somebody to do a wrong work, and that abater is a master, then also vicarious liability is applicable. But this is in general, and in criminology we see this way. In law of tort, we always go to the third classification, which is spatial relation. So we discussed about ratification, abatement, and now we are going to discuss about the spatial relations. But before that, make a note that in law of torts, only spatial relation, the third point, is applicable, not the first and second, because they are related to crime. Now in tort, spatial relation is what? The typical relation which are held between the service provider and the service taker. The first relation is master and servant, means the person who pays somebody to provide him the services. The second relation is agent and partners, and the third relation is owner and service provider. So such relations like master and servant, agent and partners, and owner and service provider, in these cases, any wrong or any act done by the servant, partner, or service provider, for that master, agent, and owner respectively will be liable. So from where is the origin of this liability? Now there are two maxims, Latin maxims, which govern the vicarious liability concept. The first is qui facie per alium facet per se. I repeat, qui facie per alium facet per se. It means in English that the one who acts through another, it is deemed or presumed in the eye of law that the work is done by himself. So this clearly holds the master applicable, that if he gives the instruction to a person who is a servant or any person who is giving a service to him, then any act done by the person who is doing so, the master is liable. The second maxim is respondent superior, which means let the master be liable. So second maxim straight away holds the master liable for the act. And as per the law of equity, as per the concept or principle of equity, that is also justified, because it is believed that the owner, he is liable, because on monetary basis or economical basis also he has a strong pocket. So he has to be made liable if he is giving an instruction. Now what are the elements of vicarious liability? Vicarious liability has three elements. The first we have just discussed, the relation. There must be a relation to apply the vicarious liability, and that relation can be master and servant, agent and partner, or owner and service provider, or any other such relation. The second thing is the act has to be done during the due course of employment. The servant might have committed the act during the course of employment and not outside that employment. The third is the authorization from the master, which means the authorized work. So master, if he authorizes the work, he is liable. But this third point, it is debatable, because in the some case laws this was neglected, which we will see now. Now let's go to the case laws. The act of the agent during the working hours, during the course of employment, the point 2. To support that, there is a famous case from English jurisdiction, which is Lloyds versus Smith. In that case, the principal was liable because the agent, actually he did some forgery, he cheated a customer during the working hours in a bank. So it was held that the principal was liable because the work was done, the act was done, the fraud was done during the working hours of the office. Although the agent did it for his benefit, but since, and it was not in the knowledge of the principal, it was not in the knowledge of the master and the agent did it for its benefit only, still the master was liable because it was done within the premises and during the course of employment. Alternative to that, there is another case which is State Bank of India versus Shyama Devi. In that case, the act was done, the fraud was done outside the hours of employment or the course of employment. So that is why in that case, the master was not liable and the person only was liable because he committed the fraud outside the working hours. So here we have seen that in the case of Lloyds versus Smith, although there was no consent or no authorization from the master, but even it was liable. While in the second one we have seen that the fraud was not done during the due course of employment and hence master was not liable. Now we will see other cases also in relation to that. Now as we seen that there are certain conditions when master will be liable for the act of the servant. So let's see what are those conditions. The first condition is if he lent the servant to another person but still giving him instruction, the master will be liable. So it means that just sending the person to somebody for some work, it doesn't mean that you can absolve from the liabilities of giving the instruction to the servant, provided you are still giving him the instructions. The second condition is fraud by the servant in the course of work. So as we have seen the SBI versus Shyama Devi case and Lloyds versus Smith case, both related to the fraud of the servant during the course of work. The third category is theft by the servant in the course of work. In that case also master is liable. The case here is Morris versus Martin of Queen's Bench 1966 from English jurisdiction. The facts of the case are that a coat was given to a master and master gave it to the assistant for dry cleaning during a shop. Now the assistant steals it, but since it is done during the working hours or the employment, so that's why master is liable for this theft. Fourth is a mistake of servant. The case here is the Poland versus Parr and Sons. What happens in this case, the facts are that a sugar bags were there in a wagon and the carter was there. A boy came near and the carter, apprehending that he will steal the sugar, he started beating that kid. And due to multiple injuries, that kid lost his leg. Now in that case also it was held that the master is liable because although the carter made a mistake, but it was done during the working hours or during the course of his employment. The fifth category is the negligence of a servant. Here the reference case is Century Insurance Company versus Northern Ireland Road Transport Board. It is belonging to English jurisdiction and it is a 1942 case. Now what happened in this? There was a servant, he lit a cigarette near a petrol pump and there happened a fire and loss of property to the pump owner. Now in that case, the court held that the master is liable for Servant Act because it was done in the course of employment. So we have seen that course of employment is very significant in determining the offense. So here we can see from SBI versus Shyama Devi, we have seen that there was a course of employment, but act was done not in the course of employment, and that is why no liability was held for the master. Now another case we can see for the course of employment is Beard versus London General Omnibus Company. It is 1900 case. Now what happened in that case? The driver of a bus, he left the bus for lunch and it was done after the last stoppage of the bus. Now conductor who was present in the bus, he operated and started turning the bus and he started the bus, and in that process he injured the plaintiff. Now what the court held is that since the duty was not assigned to the conductor by the owner, it was an unauthorized work and also was not in the due course of employment. Hence, master is not liable for this act. However, opposite to this, with the same company, the 1862 case, which is Limpus versus London General Omnibus Company, the company was same. Owner prohibited the driver not to compete during the driving, but still driver did so, and he committed an accident in due course of employment. And since, although the owner told him not to do, but still because the act was done during the course of employment, the master or the company was held liable. So this all case law you can see there are multiple references, the situations and the typical analysis we did. It shows that the liability of master is dependent on, for sure, the relation, then the due course of employment, which is very, very key factor in determining the responsibility. And the third is the authorization by the master, which is not so important because in certain cases, if act is done in the due course of employment, then the authorization loses its relevance. So this is all about vicarious liability. Now in the next class, we'll see what are the general exceptions or defenses which a person can seek to avoid the tortious liability. And that is a very important lecture because that determines the true case history in relation to the law of tort. So see you in the next class. Till then, bye.